Welcome to the D2R podcast Legal Opinion Series. I'm Ryan, and joining me is my co-host Danny and the American law firm's very own attorney John Hansen. Welcome both of you, and thanks for joining me today.
Well, it's good to be here. Thank you.
Hello, hello.
Danny, are you happy to be here?
I'm happy to be here.
Good.
All right. First, let's give our audience a little information about what the Legal Opinion Series is all about. Basically, the Legal Opinion Series gives our audience a unique opportunity, which is they get a chance to ask a lawyer a question and get some advice on their particular issues, as well as a chance to hear some legal opinions on current topics in this area and in the news from an actual attorney. During today's show, Attorney John Hansen will be answering frequently asked questions spanning numerous areas of law. For future shows, you can submit your questions or topics you would like discussed on D2R's Legal Opinion Series by emailing us at d2rlaw@gmail.com, and we will get to them on a future episode. So first, let's start with you, John. Can you tell us a little about yourself, your experience as an attorney, and the American law firm in general?
Sure. Well, first of all, I appreciate the opportunity to be here to answer questions. And like you said, the real value to this whole thing is people sending in their questions, your listeners emailing different thoughts they have, because I want to answer actual questions like these, and keep sending them, and I'll give them my best. And I don't know everything, but I know a hell of a lot, so I'll do the best I can. So the American law firm, we're based in Rockford. We're located near the intersection of Mulford and State, and we are what's called a general practice firm, which means we work in many different areas of law. Pretty much almost anything someone needs to encounter, we can handle. We have 9 attorneys that concentrate in different areas, and it's one of the specialties of our firm is that we can handle a lot of different things. I'm the managing attorney, so I oversee cases and I meet with people that come in for their consultations. So it's kind of a breakdown of who we are.
Okay. One thing I noticed on your website, it talks about your attorney fees as being flat fees. How exactly does that work?
Yeah, I'm glad you asked that, because it's not the norm, I think, around Northern Illinois for law firms to do flat fees. Retainers are traditionally the common way that attorneys will take a case on, and where someone pays an amount of money and the attorney bills from it in increments. A phone call gets a bill, a meeting gets a bill, going to court gets a bill, and so there's always this question mark at the end, like how much someone has to pay. Flat fees are becoming more popular, especially with clients, because we tell them, here's what your fee is. As long as we're done within a certain amount of time, certain amount of court appearances, certain amount of office conferences, whatever it may be, you're done. So you know up front how much it's going to be. Helps people budget very much more than retainers used to. We do retainers once in a while, but it's mostly flat fees. And for people that have financial issues that still need our representation, we'll do payment plans for a lot of clients too, where they'll pay something down to start out with, and then we structure something that works for them and works for us. So we meet people where they are, for sure.
Okay. Some people may not have ever had to deal with a law firm before. So what can a potential client expect when they visit the American law firm?
Well, we start out with our consultations, like I mentioned, and we do free consultations first, where someone can come in without paying and talk to an attorney, often me, but sometimes other attorneys, and tell us what their issues are, tell us what their goals are, and then I can kind of translate that into how much work there is, and I can tell them what the fee would be. So that's how we start. And one thing I like to say is I know it takes, for most people, a lot of courage to come see a law firm, because it's not usually something you do very much. I relate it to going to a doctor. You go to a doctor many times in your life, and you know what the procedure is, and you can know where to find a doctor, and you know what's going to basically happen when you get there. Most people have never been to a lawyer in their lives. Maybe they go once, maybe twice in their entire lives, so there's a lot of anxiety. So to help ease that, I always point out that we do free consultations, listen to somebody, find out what their issues are, translate that into some goals, and then take it from there. So one step at a time. That's one of the features we do. Also, I want to point out that when we do take a new case, we first take it to our staff meeting, which we have once a week, and all the attorneys are there. So it's a big round table of attorneys. And everyone hears the case and kind of diagnoses what we need to do. And that's a rare thing. It's like you're not paying for 9 lawyers to look at your case. You're paying for basically 1 lawyer, but it's a team approach. So that's just a couple things that are different about the American law firm I'd like to point out.
Very cool.
So thanks for asking that.
Mm-hmm. I guess let's get into some of the frequently asked questions.
Okay.
First one concerns family law. How is legal custody different from physical custody?
That's a big question. And the answer works for both divorce cases and non-divorce cases, what we call paternity cases, which are girlfriend, boyfriend having babies. It's the same thing either way. Legal custody refers to decision making, access to big decisions. So if you have joint legal custody, that means mom and dad both have access to the doctors for the medical decisions, teachers for PTA meetings, coaches. There's no one person calling the shots. If somebody wants to move out of state with a child, both parents have to be consulted. The norm with divorces and the norm with paternity cases is for joint legal custody to be given. It's a little bit rare to have sole legal custody in one parent, but it does happen. And we can arrange for that if that's necessary. That's legal custody. Physical custody is where the children spend their night during the week, who they live with a majority of the time during the week. And in our world, traditionally, moms have physical custody.
Right.
And not always. Dads have it sometimes too. But it's kind of traditionally to have the joint legal with mom having physical. If that's the case, then dad has visitation. It doesn't have to be that way. There's no statute that says that. It's just kind of been the norm, but it definitely can make exceptions for certain families. Everybody's family is different. Everybody's needs are different. So that's how the two play in to each other. And if you have physical custody, you get child support paid to you. So physical custody, I think, has more effect than legal custody day to day.
So only physical custody can get child support?
Yeah, whoever has that receives support.
Okay.
And you don't normally see joint physical custody where it's 50-50 time. You do see that sometimes, but it's rare. Because kids can't spend 1 week in one house and 1 week in another house. Or usually you'll see it with infants or maybe 1 or 2 year old kids. They can kind of bounce around, but after that, you're eventually going to see one parent getting primary residential custody, which is another name for physical custody.
Okay.
What type of attributes assist the parent in actually being the one that gets the sole physical custody?
2 things. One is history, meaning whoever's had the primary time with the child or children historically is going to have a leg up on the other parent, because the courts are reluctant to take a kid out of one home that's used to being there week to week, putting them in a new home.
Okay.
So if you're a mom, you give birth, you're probably going to have the baby with you for months and months, and so you kind of already have a leg up. But sometimes dads, when they're in a marriage, a dad will stay home, maybe be a stay-home dad. He has a leg up because he has historically been the caretaker day to day. That's one element. The other element is current circumstances. So the judge will look at history, then he'll take a look at now, because history can be disregarded if it's not working now, meaning the mom or the dad who's historically been taking care of the kid now has problems. And there's been some major problems like drug abuse, physical abuse, the child's not getting food, doesn't have shelter. That can destroy the history. So that's the 2 kind of elements to boil it down, the past and the current. And so when you see a child taken out of a home where they're used to being and moved into a new home, it's because the situation's bad. Okay. And that usually means abuse and neglect.
Thank you.
Interesting.
Yeah, you can see this kind of area is very emotional too. Some areas of law are dry and transactional, like doing a real estate closing, but family law by its nature, as you probably understand, entails so much more emotions and human beings' lives, in a sense. Also like criminal law too, you get a lot of emotion with that too. Families, children, stuff like that. We also do DCFS work for parents who are being charged with abuse, and that is a whole other emotional type situation. Very difficult to work through the DCFS system. And I think they do a hell of a job, the DCFS agents, but they do have a lot of work to do. You know?
Well, especially with their caseload. Exactly. Especially within this state, I should say.
Right. I mean, doctors, teachers, they're all mandatory reporters, as they say, so the DCFS probably gets tons and tons of complaints, and they can only do so much. So, very emotional area of law.
All right, Danny,
All
you have
right.
one?
So the next one, and actually this is something that, at least for me, having a family as well, I know this is something that I need to have locked down. I do not, so this one pretty much speaks to me.
I'll see you next week sometime.
All right, that flat fee, right?
Yeah.
Okay.
We'll talk.
So with this example or this question, my mother recently died without a will, and what does the law require me to do?
Okay. So What talked about your family? What's your family situation right now? You have children.
I have one. Yes.
Okay. Are they? Is it a minor or an adult?
An adult.
Okay. And when it comes to a will specifically, a lot of young people with kids don't think of a will as being that necessary right now. Most people who are in a younger bracket think of wills as when you're old or if you're rich, you need a will and something like that. But even if you're young and you're a parent, a will has a very important part of it, which says who takes care of your child if something happens to you.
Right.
It's called the guardianship provision. So anybody can benefit from a will. And once they're done, they're good forever. So it's not like you have to go get changed that much down the road. But so when you die without a will, going back to your question, there's a statute in Illinois that says what happens. And the statute says whatever you have goes to your children if you're not married in equal shares. If you are married, then half goes to the spouse, the rest goes to the children. If you're not married, you don't have any children, then it goes to other people. So there's all these kind of brackets filled out by statute. That's not the end of the world, but it just means whatever you kind of wanted to happen isn't followed through with. There's no way to get around that statute. If someone doesn't have a will, then the statute controls everything. And so that's why you have a will, and so your wishes, whatever they may be, can be followed through with.
You hear cases all the time about people contesting wills. I mean, what brings somebody, like, whether or not, especially if it's children, brings them to the point where they know what was the intent of the individual that put the will forward, signed off on it, had it notarized, what have you. Right. But then that individual then comes back and says, you know what, I'm going to contest that. I don't agree with what was in the will.
Yeah, that's a good question. And I'll encourage anyone listening to call and make a consultation appointment with us if they have questions about this, because all the answers I give are kind of basic, one size fits all, but everybody's situation is different. So I encourage listeners to get their own story, in front of me so I can give them a diagnosis individually. But to get to your question, the two most common reasons why we go into court contesting a will would be because we feel like the person who made the will out did not know what they were doing at the time because they had Alzheimer's, dementia, whatever. They didn't know what they were doing. And that's rare, but that is probably the most common reason why we would go in to try to contest the will. The other reason is we go in because the spouse was left out of the will, and by law, Illinois says a spouse can void a will if they're left out of it and take half of the entire estate. It's called the spousal share. That prevents the spouse from, screwing the other spouse.
Okay.
So there's that protection in place. So that's the second, probably most common reason we have people come in. Now, when it comes to fighting in court over an estate, we're not talking about fighting the will. We're talking in a different sense about somebody whose executor is not doing their job right. So besides contesting a will where we think the person who made the will didn't know what they were doing because they were out of their capacity or because some spouse got left out of the whole thing, the main part of this whole thing is when there's some executor leaving everybody out of the whole picture, not doing their job right. So we're representing beneficiaries who are being not given what they're supposed to.
So what's the difference between a will and a living will?
The will refers to when you pass away, where your stuff goes. There's at least two things in your will. One is who your executor is, which is who's in charge of making sure your wishes are followed through with. And then at least there's a decision as to who your beneficiary is. It could be anybody. Living will just talks about, it's very important, but it talks about specifically whether you do or do not want to be kept alive on life support machines or technology when you're terminal. It sounds kind of specific, but it really is a common thing where if you're elderly or you're in a coma and you're young, the doctors are only keeping you alive on the respirators and the machines. At that point, they go to the family and say, okay, what do you want us to do, family? We can end the machines, take them off, pull the plug, as people say, and the person dies. Or we can leave them on. We need a direction here, people. And it's a tough decision for family to make because either way, it's a bad deal.
Right.
And so this at least tells the family, the loved ones, what your wishes are, the person's wishes are, so it takes a bit of a burden off. 99% of people say, if I'm terminal, let me go. Give me pain meds so I'm not hurting, give me food and water, but don't keep me on the machines. A very small minority will choose to be on for various reasons. So that's a living will.
Have you seen situations or cases where the living will has been created, signed off, once again notarized? Family members have been informed of what those wishes were, but when it gets to that point where someone's incapacitated to be able to say, pull the plug, and then there is one of those individuals that says, I'm stepping forward and saying no.
Yeah. That's a really good question. I haven't seen it very much because the very purpose of the living will is to avoid that situation. So I've seen it in the news, not in our firm, not in any case that I've handled, but in the news I've heard of, some celebrities that have been, families who've been given that situation, and there's been some contested stuff there. But even if there is an outlier family member who just will not go along with the program and doesn't care what the living will says, it doesn't go very long because the living will is ironclad as long as it was done right. And there's not much place they can go. The doctors will say, look, one family member, the rest of the family showed me this living will and the lawyer said it's legit, so sorry. So they can only raise so much of a fuss. Recently in the news, Casey Kasem died. Probably not a lot of people know who that is, but it's an old radio guy. Radio guy who did the top 40 stuff forever. But he had Alzheimer's, really a serious advanced level, before he died for a while, and there was this big legal battle as to who was going to take care of him. He had this new wife, his children from his older wife were involved, and it all could have been cleared up if there had been a proper instrument prepared that said, here's what I want, here's what I don't want. So you see it with celebrities, but it does commonly happen with people. It's a really messy situation. It tears families up. It really creates a lot of bad blood that goes on for a long time after the person has died.
So it's a good idea to have them.
Yeah, come in and see us. We'll give you a free consult and we'll talk about what documents work for you and what don't. And there are other documents out there that apply to this situation too that we haven't covered.
Thank you.
Very good. The next topic is bankruptcy. Me, not specifically me,
right.
But in general, this question gets asked. I need to file a Chapter 7 bankruptcy, but I'm told my income is too high to file due to the bankruptcy rules. Is there anything I can do to get out from under my debt?
Yeah. And I know it is you, so don't worry about it. No, I'm kidding. So when it comes to income, the bankruptcy rules, which are federal government rules, because bankruptcy is federal law, they have these caps on income. If you have over that income, you can't file Chapter 7 unless, and the unless is what I'll talk about. But the caps go by household size. So if you're a single person, there's a pretty small number that you can make. If you're a household of 2, then there's a bigger number, and so it goes on from there. If you're below that amount, there's no problem. If you're above that amount, you still could file, but you have to pass what's called the means test, which is what we do with clients. The means test, long story short, is basically saying, yes, bankruptcy court, I do have over the limit, but here's what I have to spend it on every month, and this is why I don't have any money left over. So if we show allowable, reasonable expenses every month, because you have a lot of people in your family or you have a lot of bills to pay, then you can still squeak by. So it's an issue, but it can be worked around in some cases.
Okay. What's the difference between Chapter 7 and Chapter 13?
Yeah, Chapter 7 is the one-time discharge of debts type bankruptcy, and it's probably the most common type of bankruptcy people do. It's you file bankruptcy and all your debt's wiped out. Chapter 13 is the second most common for individuals. It's where you pay your debt, or most of it, through a payment plan for a series of years. So you're not bailing on your debt necessarily, you're just paying it at a lesser amount that you can afford, less than the creditors would like to have. The most common trigger for a Chapter 13 is a bankruptcy or is a foreclosure case. So if someone's behind on their mortgage, they're in a foreclosure lawsuit, they want to save their house, and they file Chapter 13 often to save the house. They're still paying the mortgage, and they're paying the past due amounts, they're just paying it through the bankruptcy courts. The minimum length of bankruptcy Chapter 13 plans is 3 years, the max is 5, so it's a big deal to get into a 13. Many 13s fail after a year or two because people thought they could do it, they couldn't make the payments, and they could do a Chapter 7 at the end of the day. So we sit down with clients at the front end and see if they're really able to do a 13 or not before we launch them into that program. So that's the difference.
Okay.
Right. The next one is about family law. So with a lot of, in my line of work, I see with my clients and my consumers where not only is the traditional guardian or parent no longer able to care for the child, so it's usually the grandparents that step in to raise the grandchildren. So with this particular question that's asked often, do parents have rights to custody or visitation?
Yeah, grandparents do have rights in Illinois, and the rights are really specific. So where it comes into play is if a grandparent has been prevented from seeing their grandchild, that's a situation that can be remedied, and that would be visitation. They're just not being able to see the grandchild. They don't have any time. And so we can file petitions if we need to, if we can't work it out between the parties directly, to enforce some kind of visitation schedule so they can have an influence. And normally when that happens, it's because the child, meaning the father or the mother of the grandchild, is out of the picture. The most common trigger for a grandparent to come into our office is my son or my daughter is in the military and they're overseas or they're in prison or something like that. I need to step in and make sure my grandchild's being taken care of.
Oh, okay.
I don't have any access. I don't even know what's going on with the grandchild. I'd like to kind of insert myself to kind of be standing in the shoes of my child who is the parent. If that's the case, then there's a definite avenue you can pursue as a grandparent to step in the shoes of your child. So not only can grandparents on their own just kind of have visitation time, but you can also step in the shoes of your child who's out of town or unavailable or passed away to essentially kind of be the other parent.
Okay.
So it's very technical. There's certain things you have to show in court. It's not just handed out to every grandparent. There's certain situations you have to prove. And so I can talk about that at length for people to come in. But yes, there is a right to grandparents' visitation, and there is an enforceable way to do it in court if it can't be worked out amicably between the parties. And, like you mentioned, very often when we have a person come in who has a child, their grandparents come in with them. Grandparents are super involved in young people's children. So if we have a young guy who had a baby with a girlfriend, a young girl who just had a baby with a boyfriend, grandparents are really a big foundation for them, emotionally and in other ways. So heavily involved, and that's a good thing for sure.
Yeah.
That support system,
Thank you.
as you probably know in your experience.
Oh yeah, definitely.
All right, the next area is expungement. Once again, it's not me.
Yeah.
You have a friend?
Uh-huh.
Yeah,
I have this friend.
I have a friend.
My friend John Doe has an
Yeah.
extensive criminal record.
If I have a criminal charges from the past, can I get them expunged?
Yeah, it depends on the charges. So if you have a case that you were charged with, but you got it dismissed, you beat it, or you went to trial and you won the trial, you're not guilty, those can be expunged normally because you weren't found guilty. It was either dismissed or you won.
Right.
When you're convicted in some way, that's a little bit tougher. So conviction means either you pled to it, obviously you pled guilty, or you made a deal where you got probation, or you made a deal where you got court supervision. Any of those kind of deals technically mean you're convicted. And those necessarily have to go through a little bit of a process before you can do something about it. And usually you can't expunge anything like that. So expungement is always the goal, because what happens is the clerk's office, if you are given your expungement, they destroy the records, they shred them, they're gone. Nobody can get them at all. The second route is called sealing. Sealing the records means literally they take the records, the clerk's office, and they seal it up in envelopes and put it somewhere. And nobody can ever see it on your record. No employer, no landlord, no military viewer, whatever. The thing is, the records are still out there, though. So if there was ever a future criminal case, FBI, the state's attorneys, they can dig it up if they had to. But for most people, it doesn't matter. Sealing is just as good as expungement for most average folks who just don't want anyone to know or see that record. So not convicted, yes, expungement. Convicted, probably sealing. Either way, your employer you're interviewing with can't find it. Either way, military can't find it. Either way, nobody can see it at all. So that's the main difference. Illinois has this real complex little breakdown of what your options are. So I, again, encourage people to come in and I'll run the system through whatever their record is and tell them what their options are. And there's some crimes you can't expunge or seal. They're just set out by statute. They're the more serious thing. So very complex.
What's that scenario where it's that particular age bracket or that threshold where if a crime was committed prior to, let's say, like 16, 17, 18, or whatever that is?
I don't know. I mean, are you talking like from juvie when they'll switch it over to adult? Mm-hmm. Yeah, there's certain crimes that they'll charge a minor with as an adult. Obviously, murder crimes and stuff like that. But there's also, I think a year or two, Illinois switched over where they treat 17-year-olds differently than they used to. And I wouldn't be able to get specific on that, but there's been a lot of changes as far as 16 and 17-year-olds with certain criminal charges. And it doesn't apply across the board, but they've kind of changed the rules with that a couple of years ago. We have an attorney in our office who concentrates in criminal defense, and he's the person who really knows the ins and outs of that. And he used to be a prosecutor, actually, for 20 years or 16 years, I think. So he's known both sides of the prosecution and defense. That's usually who I'll bring into the room if somebody has a good question like you did, Dan. Mm-hmm. So it's when there's a juvenile case, whether they're dismissed, whether they somehow beat the trial, or whether they're found guilty, by nature all juvenile cases are sealed anyway, just automatically. So there's no public record for any juvenile offenses. But there are options even to clear that record up if somebody for some reason just wanted to, even though they know the public record can't be seen. Some people will come in and want to clear up a juvie case. And there are options for that too.
So I know that you stated that you're off the top, you can't really recollect what or how the state of Illinois is acting in regards to that with the 16, 17-year-olds. Are they swinging more towards the more conservative route with that, or are they getting a little more?
No, it sounded more the opposite. It sounded like the trend has been to treat minors more as adults. I think it's gone that way. Like, apply more culpability to them, give them more accountability, treat them more like they should know what they're doing or something like that. So I think it's gone more as more of a harder approach, more heavy-handed is what my sense has been. Who knows why, but that's kind of been what I've seen the last couple of years. And it's tough, but there are options out there to clear up that record. Because people will have a juvie case and 30 years later still be haunted by it. Totally different person. Yeah. Not talking about you.
Yeah, once again, not me. Danny, do you have another one?
If I do, is in regards to real estate. So, if I bought my house and recently found out problems with the basement that were not disclosed by the sellers, is there anything I can do about it?
Yes. The forms when you buy a house are pretty complex, but there's one page in those forms or contracts where the seller will disclose with checking off a box on anything they know about problems with the house. And so there's this pre-printed form that says, do you know of any mold? Do you know of any previous fires? Do you know of any previous flooding? And so if you don't correctly check those off and you try to hide something, and then the buyer finds out, then they can sue you for damages, and the damages are pretty severe. The only risk with this is, or the only problem with this is the statute of limitations with this type of claim is 1 year, in most cases, although it can be changed. So 1 year, basically, to figure this out and get a lawsuit going is pretty rare. We have people come in all the time who way past that. And, obviously you don't necessarily find some history of a fire until you're bringing down walls 10 years later after you buy a house. So the statute and the law has really truncated the time you have. I think they've done that too to protect buyer or sellers, because what if a person buys your house and then kind of messes around with the house and then try to blame it on you because you sold them the house. So the longer you live in a house, the more likely it's your problem, that you did something. So it's tough. So if anyone gets any inclination that they found some problem that they weren't told about, then come see us. We'll see if they still have time to legally approach that.
And I think for me, and this is actually a personal friend of mine.
Finally,
so actually an actual real case.
Finally, a real situation.
Her and the soon-to-be mister bought a house, and with the recent rains, found out that the basement does tend to flood because the water just came right on in, and that was not disclosed to them when they bought the house. So
tell them to come see me, and I'll walk them through some options. Yeah, flooding's probably the most common one. That and previous mold issues. So very common. Good question.
Thank you.
Next one is criminal defense. If I'm contacted by the police who are investigating a crime, what should I do?
This is a really common question because of TV and movies. Everyone sees when someone gets pulled over, what are you supposed to do when the cop comes to the window? Or if some cop comes to your door and wants to go into your house, what do you do? And it's not just a fun question. A lot of people have faced this and come to see us after they've been interrogated by the police, and they want to know if they did it right or not. And they hire us to defend them in the criminal case. But so the deal is, let's take a situation where the cops come to your door. The rule of thumb is, do not speak to the police, okay? They're there for some reason to investigate something. And the best rule of thumb is, without knowing any listener's particular situation, not knowing your situation, whatever, is to not speak to them. There's no law that says you have to speak to a police officer. There's no statute that says you have to answer their questions. It's better to not answer their questions than to answer them and then say something wrong, even if it's a mistake, and then create this new problem where they want to investigate further.
So they can use that against you.
Yeah, and even if you're innocently making a mistake and you misstate something, that's going to give them a reason to investigate. Now you're wasting their time because you just made a wrong decision. So don't speak to the police in most situations. If people always say, "Well, doesn't that make me look like I'm guilty?" And isn't that going to make them pursue me
Even more? Yeah.
First off, it's better that than saying something they can actually have a record of forever. And then also, the cops aren't unfamiliar with people not answering questions. It happens all the time with police. They know why people do it. They know they deal with lawyers every day. So it's not like they're that surprised if someone says, "I don't really want to answer any questions." I mean, they'll know there's something going on, but they'll also know this person's probably been talking to a lawyer and they know the deal. So they approach it every day. It's not as unusual as we think it might be. So to play it safe, you say, "Officer, I see you're doing some kind of investigation. I don't have any real familiarity with this. I'd like to talk to my lawyer and get back to you. Can I have your card?" And that's it.
This is being recorded, right? So if anything happens down the road, I can actually use that terminology or that.
That phrase is allowable, yeah.
Okay.
All you have to do is show them an ID and tell them who you are. And beyond that, you can clam up. Now, they might be there to ask about a shooting in the neighborhood. They just want some witnesses to talk.
Right.
So you got to make your judgment calls, obviously. You have to be common sense. But the safe approach is always the least amount of information you give out. Respectfully, politely tell them who you are, and then tell them, "I don't have any familiarity with this kind of stuff. Never been in trouble before. I'd like to get back to you later on with an attorney." And then quickly, it's a big subject, but searching cars, searching houses. Police can't get into your car without your permission unless they have probable cause. Probable cause means they see something through the window in your car that looks illegal, or they smell an odor of something that gives them a clue. Other than that, they can't just say, "Get out of your car, I'm going to search your car." And then once they get in the car, there's still some limitations on where they can look. Okay, and so I'm not going to give a law school class tonight.
Right. Yeah, because that's piqued my interest here. Because
Right.
to me, probable cause seems so broad, it's so general, because that's what you always hear.
Yeah,
Probably,
it's a common phrase, but it
yeah.
has limitations.
Okay.
So if a cop comes to your window because you ran a stop sign, he can ask who you are, ask for an ID and all the driver's license stuff. He can say, "Well, I'd like to get out of the car. I'd like to search your car." You can say no, and he can't search the car unless he sees some drugs or something or a gun, in view. Then he can obviously say, "I'm going to search the car," or unless he detects the aroma of drugs, or he has a dog sniffing, canine unit that detects drugs, and he can get in there. But other than that, no, they can't get in your car. Your car is your private place, just like inside your house. The cop can't come in the house unless you give him permission. Unless they either see something going on, through the door or a window, or they detect something going on odor-wise. That's probable cause.
Okay.
And even if they get in the house, they get in the car, there's all these limitations on where you can look. So, law school, you'll go through a year studying this stuff, or at least a semester studying this stuff. So it's hard to boil it all down. The point is, they have to ask you to get in your car and get in your house unless they see something or know of something going on. In most cases. And we have right to privacy. We have rights of protection. And even warrants and stuff have limitations. So come in, the short answer is come in and we'll talk about your situation. Why all this matters is if you're charged with a crime, and in the rare event, police did something wrong, in the rare event they actually found some evidence improperly, then they can't use it against you and the case is dismissed in some cases. I say rare because cops usually know that what they're doing. They're good at what they do, they're good cops, and they take care of their job right. But if they don't, then that's used to protect somebody and have their evidence thrown out. Well, we get into all this.
Warrant thing where they come with a warrant and say, "We have a warrant to search your place of residence."
Right.
that has limitations?
Yeah, the judge will sign warrants for a specific purpose. So if there is a house, they can search within the house, but if there's a separate garage, they'll need permission for that. If there's separate areas, a shed and stuff like that, there's all these geographic boundaries that protect people. Warrants are usually pretty broad though, so the judge doesn't want the cop going over there and only be able to search one closet. So they'll make them pretty broad, but there's still limitations to that. If a cop is called over on a domestic situation, one of the people in the house call the police because there's a fight. That's a crime they're knowing of, so they can actually, if they think someone's in danger, of course they're going to come in and try to prevent someone being hurt. But otherwise, they have no real access inside the house. It's a private area, and it's protected against intrusion without a warrant. So.
And then generally, in that scenario, you should still use that same statement that you gave earlier that you want to speak to an attorney, rather than let them interrogate you on the spot.
Yep.
Okay.
And so, whole trials are based on what we're talking about. Law school classes are based on what we're talking about. So it's a very rich, deep area to talk about, but that's some of the things that people need to understand is that you do have rights. You do have privacy rights, and you do have rights to not incriminate yourself. And those kind of terms are thrown around real loosely in Hollywood and stuff, but they're real actual rights that people should find out about. And there's textbooks about it, so it's a very complex area. But talk to an attorney about your situation, they'll tell you what's going on with your particular deal. It's a lot easier when you have a specific fact pattern.
Right. The next area is bankruptcy. My spouse files for bankruptcy, but I don't. Can creditors pursue me for payment?
No, the creditors are only allowed to pursue whoever took the debt out. So if your spouse only took a credit card out and she files bankruptcy, then you're protected. If you both took it out, then obviously if she files BK, you're left holding the tab.
Right.
So spouses are often worried that they'll be somehow hurt credit-wise, credit score-wise, or they'll be sued somehow. But no, you're completely separate from your spouse financially when it comes to creditors.
Okay. So you don't, just because you're married, you don't have to file both bankruptcy.
No,
the
spouse can file by themselves.
Okay.
Where the debt thing plays a role with spouses is in divorce. So if you're married for 10 years and during that 10 years your spouse went out and got a credit card and your spouse racked up $10,000 during the marriage, for the divorce court and the divorce laws, it's still your debt too, even though your name's not on it. I mean, it starts out like that. There can always be adjustments made where one person pays all the debt in the marriage, but for a divorce law, you're entangled all the way, 50-50 at the beginning at least. So it's a whole different scenario. But no, creditors can't pursue anyone else but whoever took that debt out. And bankruptcy doesn't hurt the spouse generally.
Very good.
So this frequently asked question deals with family law. And the question is, my ex-spouse is not following through with the court orders in our divorce judgment. What do I do?
So the ex-spouse is not following through with anything in the divorce judgment. There is a course of action we take whenever there is a spouse who didn't do something they were supposed to do. So the judgment we're talking about is what is given at the end of a divorce. The judge signs it and it becomes an order and becomes law. And most commonly, like a few years later after a divorce, a spouse will come in and say, my ex-spouse was supposed to have bought me out of the house and got me off the mortgage, and they didn't do it. They couldn't refinance, or they were supposed to sell the house, they didn't. Or they're supposed to pay me alimony or maintenance, and they didn't. And so all that stuff, no matter what it is, generally is taken care of by one petition called a rule to show cause petition. It's a weird name, but rule to show cause means, judge, this ex-spouse didn't do something and we want you to hold them in contempt. Literally what you're asking for. And why do you care about that is because if they're held in contempt, they can be made first to do what they were supposed to do, but also to pay for your attorney's fees that you incurred, that you wouldn't have even incurred if they had done their job right. So rule to show cause is a big deal. Being held in contempt is a big deal in divorce. It's civil contempt, so you're not necessarily hauled off to jail or anything, but it's being fined essentially, because you have to go ahead and do what you're supposed to do, and in some cases you have to pay for the lawyer's fees as a punishment. And so it's usually real estate, it's often alimony, and things like that are really commonly not followed through with for various reasons. It's not always the person's fault. Sometimes they just couldn't modify their mortgage or refinance and something like that. So,
do you see child support falling under this as well too?
No,
Like particular...
it's handled separately, streamlined a little bit better. If someone doesn't pay child support, then we just request an arrearage amount. And yeah, you can get attorney's fees. You can ask for that in some situations, but it's not as bulky and burdensome as a rule show cause. Rule show cause is a bigger deal. There's a defense brought, and there's more back and forth arguments about, well, I couldn't have sold the house, yada yada. Child support is what it is. Either the payer can prove he paid it, or she paid it, or she can't, or he can't. There's not much back and forth. Either you paid it or you didn't. And so if you didn't pay it, you're stuck with an arrearage and you're punished. If you did, then there's no problem. So yeah, it's super common to have non-payment of child support, but it's just handled quicker in a more streamlined way. And the punishments with not paying child support can be severe, as a lot of people know. If a payer has racked up 30, 40 grand in child support and hasn't paid it, the state of Illinois has statutes in place that can take someone's driver's license, and in rare circumstances, a person can go to jail for not paying child support. And we often call that a situation where they hold the keys to the jail cell, as we say, because if they pay the money, they get out. They're not sentenced for 10 years to jail. They're sentenced until they pay it in a simple term. So they hold the keys. And I've always thought that's a little strange in a way, because if you're putting someone in jail, they're not going to go get a job and pay anybody.
Right.
But you can come up with the money somehow, I guess. You're definitely incentivized to.
Yeah.
But I'm more like, get that person a job, get them to work, and get them paying child support back. But it is a serious deal for sure.
That's similar to like a work release, or they literally.
Yeah, it's just driven. Your term in jail is driven by your finances, and it's not you're sentenced for a certain number of years. And the courts are lenient because they know people need to get out and get to work, like we talked about. So it's you don't see it very much, but it's more commonly where someone loses their license. That's kind of a first step. Jail is really down the line for a lot of people.
All right. Well, I guess that'll wrap up today's frequently asked questions.
All right.
You can make an appointment to speak with Attorney John Hansen at the American Law Firm by calling 815-394-1776. You can also visit their website at www.theamericanlawfirm.com. You can follow them on Twitter at American Law USA, or you can find them on Facebook. Just search American Law Firm. Let me give the phone number one more time.
Go ahead.
Just because.
Please do.
I think that helps. 815-394-1776. You can also submit questions or topics you'd like us to discuss by emailing us at D2Rlaw@gmail.com. That's D, the number 2R, LAW@gmail.com. And then we'll answer your inquiries on a future episode.
Yeah, so please send me your questions, and we'll see if we can get to them.
Yeah, good times. So for Attorney John Hansen, my co-host Danny, and myself, thanks for tuning in, and we'll see you next time.
Thank you.